And hello and welcome to the Employment Law Show. I'm John Scholes. He is Lior Samfiru. This is where we talk about employment law and make your head bigger and smarter and more prepared to tackle your job every day and life in general, because a lot of things on the line when it comes to your employment. Got a lot of stuff to get through today. Termination pop quiz. Am I asking you questions?
No, I'm asking you questions.
That won't be too embarrassing. We're going to get to that and a ton of other stuff, some phone calls we got from our radio show. But first, as always, brother, we get to the week that was. What's going on?
Great time in my office. A lot of questions answered. Myself, my team, we're on the phone, we're on email all the time, answering so many questions. People that watch this show, and it triggers something, a question, an issue, a problem. So if you're in that situation, if what we're talking about reminds you of an issue you're facing or maybe have faced in the past, call me, email me. We'll give you that contact information throughout the show so we can talk about it. But we're here to educate you about employment law and workplace rights and tell you what you need to know about the place you spend so much of your day, of your year in. Week that was, John, situation that came across my desk just over the past few days. I spoke with a lady who unfortunately recently got divorced, and she took sole custody of her child, young child, 3 years old. And now that she's a sole mother and a single mother, she had to make sure that her child gets to daycare, gets back from daycare, and unfortunately this interfered with her work schedule. She had to have her child at school by a certain time in the morning, and she had to pick her child up by a certain time in the afternoon. And there was about half hour in the morning and half hour in the evening that it didn't match up with her work schedule. She doesn't have any parents around. She really is the only one that can do this. She's on her own, unfortunately. Well, she spoke to her employer, and she said to her employer, I need you to help me out. I need to be able to come in half hour later and leave half hour early. And that's fine. I'm not expecting to get paid the same. You can adjust my pay. I just have to be able to get to my child. But I said, no, that is your issue, not our problem as your employer. So you have to manage that on your own. She called me upset, literally in tears. Is that the company's issue? You bet it is. Absolutely it is. It is the company's issue because the company has a duty to accommodate. We call this accommodation based on family status. Yep. If you're in a parent and child relationship, if you have responsibilities towards your child, in this case, to get them to school, to pick them up, to make sure that they're cared for, and the only way you can meet those obligations is through accommodation by your employer has to provide that accommodation. They can't say no. They can't say it's not our problem. It becomes the company's problem. That doesn't only apply to a family status. Oftentimes we see that in the context of disability. You may have a medical condition that the company has to accommodate, modified duties, modified hours, etc. The company has a strict duty to accommodate, even if it's difficult, even if it's not easy, even if it costs them some money, they still have to do it. And if they don't, like in this case, that is a human rights violation. It's illegal. So I'm going to help her get some compensation. Hopefully, I won't even have to go there. Hopefully, I can send a letter to the company, give them a kick in the pants, and they'll realize, okay, yeah, we do have to accommodate. She can go back to work and everything is fine. If they still refuse, we're talking compensation. So remember, if you have a family responsibility that you have to meet, if you have other accommodations that you need, maybe based on for religious reasons or a medical condition, company has to accommodate. If they don't, I want you to reach out to me.
Is there would there be a limit? I mean, her case was a half hour in the front end, half hour in the back end. Say she had to leave work at 2 o'clock, but she normally works until 6. I mean, that's a pretty big change. Is there a fine line to how far a company has to go?
So at some point it does become too much. Yeah. At some point it gets to be too difficult, too much, too extensive for the company to accommodate. And that's when they reach the point of undue hardship. It's just too much. It's difficult to get to that point because the company is expected to suffer, if you know what I mean, for lack of a better term, in accommodating. So would 2 o'clock instead of 6 be too much? Maybe, maybe not, depending on what the company can do to make up for the hours. Can they find someone else? Is it not a big deal? And the bigger the company, the more they're expected to do.
They have resources.
They have resources. If you're talking about a major bank, they have thousands of employees, they have more financial resources, they're expected to accommodate.
So if you're a small mom and pop shop, a little bit of a break.
A bit of a break. Yeah. It's understood that you won't have the same flexibility, but the duty to accommodate is still there, whether you work for a big company or small company.
You want to reach out anytime, 1-855-821-5900, and it is EMPLOYMENT online. That is also where you can go to catch one of our radio shows. We've been doing it for, feels like forever. We filled a lot of people with some good information, and we get a lot of calls on the radio shows. We're going to pull a call from the radio show, first one for today, and we'll talk about it, right? First call for the day right here.
I'm calling on behalf of my friend working in a call company, and now she has been put on a performance plan just to monitor her performance and everything. Basically, they just want to let her go, I guess. So she's just wondering what are her entitlements and all those things, like what she can do. But she's still working, though.
Yeah. It's an excellent question, and oftentimes when someone is put on a performance plan, it's a step towards a termination.
Right.
Company is thinking about terminating, potentially terminating for cause, and they're trying to build up their case by putting the employee on a performance improvement plan. Well, let's talk about that. Just because you're put on a performance improvement plan does not mean that if you don't meet those obligations, or if you don't meet those terms, the company can let you go for cause. Remember, it is very difficult to terminate for cause. Even if you've done something wrong, even if you've been put on a performance improvement plan, it does not mean the company can let you go for cause. Remember, they can let you go without cause at any time, but they have to pay severance. The thing is about a performance improvement plan is this. If you don't agree with something, if there's elements in it that are not accurate, you have to say so, and you have to say so in writing. So if they say you've done X, Y, and Z, and you don't think you did, or you only did X but not Y and Z, say so. Make sure that they know. Don't be silent. Silence is the same as acceptance, as agreement. Don't agree to something that you shouldn't agree to. But even if you don't do that, and ultimately the company lets you go, it does not mean they have cause. Yes, you would still be owed severance. You would have had to do something awful, something nasty, for you to be let go for cause in a legal way.
I guess sometimes you see this in a sales position where it's, the performance improvement plan could be something as we've raised your quota, and it might be an unreachable number, and it's like, guys, I can't reach that, and they're going to let you go.
Yeah, and they can, but they have to pay you severance. But if they're going to give you quotas that are unreachable, if they give you milestones that you can't meet, say so. Because later on, it's going to be difficult to say, well, back 6 months ago, I knew I couldn't have done it. Well, then why didn't you say so? Why didn't you tell the company that it was unreasonable? Say it's unreasonable. Outline what you disagree with. Don't be nasty or aggressive about it, but you have to be very clear about why you agree and what you don't agree with, and why it may be impossible for you to meet the milestones that they've set.
Again, it's EMPLOYMENTLAWYER.ca, help at EMPLOYMENTLAWYER.ca through email, and 1-855-821-5900. That is the number to reach out and contact. Super excited about this. Give me some details. Things keep getting better and better as far as what you're doing on the online world. Pocket Employment Lawyer. This is pretty cool.
So a few years ago, I created the Severance calculator that allows anyone to find out how much they're owed. But a lot of people want to get additional information about their rights, about can their boss do something? Are they employees? Are they contractors? So I created a new tool, online tool, PocketEmploymentLawyer.ca. PocketEmploymentLawyer.ca, because it's like having an employment lawyer on your phone, in your pocket, with you at all times. So what happens when you go to PocketEmploymentLawyer.ca? There's be a number of categories you can choose from. Maybe you want to know if you've been constructively dismissed. Maybe you want to know if you're an independent contractor or an employee, or if the company has cause to let you go, or how much severance you're owed, or if there's a human rights you've been discriminated against. And once you pick that category, you're going to answer a few questions, and you're going to be told, yes, you have been discriminated. Yes, you are an employee. It's going to give you the information that you need for your specific case based on your answers. So it's like having me available with you at all times. Check it out, PocketEmploymentLawyer.ca. If you ever had a question about your legal rights, if you have a question about your legal situation, no need to wonder anymore. There's literally no such thing online. Doesn't exist. Just created it. Check it out right now. PocketEmploymentLawyer.ca.
Well, like we used to do with the severance pay calculator, it's always good to take a run at it and see how it works. I'm going to give you this one from Pocket Employment Lawyer we got before the show. It says, my boss has decided to change my compensation structure after 12 years. She said that the company will no longer be paying bonuses to employees. They're all done. Roughly 25% of my pay comes from a performance bonus. That's a big chunk of change. What are my options?
So whenever we're talking about changes to the terms of employment, changes to compensation in this situation, we think constructive dismissal. So when you go to PocketEmploymentLawyer.ca, you'll see a section dealing with changes to compensation. So once you go there, you'll answer some questions and you'll find out, yes, is this a constructive dismissal, or no, it isn't. So let's take this scenario that you just read. Let's plug that into PocketEmploymentLawyer.ca and let's see what we get there. So we know this person has been there for 3 years. They would input 3 years. We know that the thing that has changed is their compensation, not their hours of work, not their responsibility, the compensation, the bonus. Was it reduced by more than 5%? They'd say yes, of course, because it's 25%. And has the employer done this before? You answer that. And the result you can see on the screen, it says, yes, this is likely a constructive dismissal situation, which may allow you to leave the company with severance. So it confirms and it checks the fact that this is really a constructive dismissal. Depending on the answers, they could have said, no, it's not a constructive dismissal. So it accurately assessed the situation. And yes, in fact, to elaborate here, John, if your bonuses changed, they haven't touched your salary, but they touched your bonus, but the net result is you're making less money, yes, of course that is a constructive dismissal. Unless they've done it before, unless there's a history of doing that, your employer does not have a right to change your bonus in a significant way. If they do, you may have the option to treat that as a constructive dismissal.
That's why this is so cool, because the average person would think, and I'm sure the average employer would come back and say, hey, bonuses are discretionary. Never mind the history of 12 years, but bonuses are discretionary. I'm not going to pay it this year. No big deal.
It's more than that. They may even have an employment agreement that you may have signed 12 years ago that says bonuses are discretionary. And they'll say, well, you can't read. Look, it says discretionary. But it actually doesn't matter. If you get a bonus regularly and it's something you can count on, it becomes a term of employment. The fact that 12 years ago you signed an agreement that says they don't have to pay it doesn't matter. They are paying it. It's something consistent. You're counting on it, which means they can't change it. But it also, John, means that if they let you go, they have to pay your bonus as part of your severance. So if you're owed 12 months severance, what that really is, it's 12 months salary, 12 months bonus, 12 months benefits, car allowance, pension contributions, commissions, everything you would have received had you worked there. And the company can't hide behind those words, discretionary bonus. If it's something you've always received, if you're consistently receiving it, it's a term of employment.
Clark Griswold could have used that information.
Well, he was putting in a pool.
Well, you know, yeah. He'll fly everybody down there. We'll take a short break. Coming up here, the Termination of Employment pop quiz. Thank you very much for that. It's for me. 1-855-821-5900, EMPLOYMENTLAWYER.ca. Lots more employment law shows on the way. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to EMPLOYMENTLAWYER.ca.
Always check with the employment lawyer first at EMPLOYMENTLAWYER.ca.
And welcome back to the Employment Law Show. John Scholes, Lior Samfiru. This happens once every couple of years. It's kind of like Halley's Comet, but a much worse result. And that would be the Employment Law Pop Quiz, Termination of Employment Pop Quiz. I guess they call it a pop quiz. I didn't know about it, so we're going to see how embarrassing this is.
Listen, you always ask me questions. I want to make sure that some of the things we talk about, I've actually registered, that you've internalized them. So I'm going to ask you some questions, John. But the good news is, regardless of what you say, I'm going to elaborate. I'm not going to make you elaborate. So don't go and talk to your employer until you hear me give the actual answer. John may get it wrong, but we'll see.
Don't sugarcoat it. All right, get to the first question.
All right, we're going to start. So these are questions. John is not the employment lawyer, but he's going to pretend for the next couple minutes. Yeah. So, John, what is actually the difference between termination pay and severance pay?
There is no difference. Different name. They're called different things.
That is essentially correct. You're right. Technically, there may be some differences, but it doesn't actually matter. When it comes to termination of employment, what we care about is what you're owed, the compensation that you're owed. Some people call it termination pay. Some people call it severance pay. Some people call pay in lieu of notice, right. Notice pay. It doesn't matter. The compensation that you're owed after you left your job, after you let go from your job, is here we refer to it as severance. Now, with respect to your minimum entitlements, there may be a distinction. For most people, it doesn't matter. So I don't want you spending any time worrying about, is this termination pay, is this severance pay? It doesn't actually matter. What matters is, what am I owed if I lost my job? How many months' pay am I owed? We call that severance pay. That's all that matters. So John is right. It doesn't really matter. 1 for 1.
Let's go.
1 for 1. Yeah. Quit while you're ahead.
Yeah, it's going to get worse.
So, John, your boss said that they're letting you go for cause,
Okay.
which may happen, you never know,
Or
because you missed last month's sales quota.
Yeah.
Are you owed any severance pay?
Yeah, that's not enough to let somebody go for cause.
What would you have had to do to be let go for cause?
I would have had to maybe take a swing at him or do something a lot worse in the workplace or have a history of this over many years of not making my quota. Be a
Or
series of
almost
warnings or
deliberately
Deliberately?
done a bad job.
Yeah.
So John is absolutely right. It's very difficult to terminate for cause. 2 for 2, John. That's awesome. It's very difficult. And the fact that John may not have met his quota does not mean that that's cause. Now, he may have not. That's not a good thing. He should have meet his quota if it was a reasonable quota. But the fact that he didn't does not mean it's cause. It's very difficult to terminate for cause. So you may have done something wrong. Maybe you've done a few things wrong. It does not mean you can be let go for cause without severance. In the vast majority of cases, John, over 90% of the time, when someone is let go supposedly for cause, it's not actually cause and they're owed their full severance.
We're doing the termination of employment pop quiz here. I'm on the hot seat. To reach out, by the way, anytime and relieve me. 1-855-821-5900, EMPLOYMENTLAWYER.ca. This is worse than getting your arm waxed. All right, number 3.
Number 3, John, how long can a temporary layoff last?
They're not legal in the first place, so there should be one. But if there is one, I guess there's a history involved with how long it was the first time. 13 weeks, 15 weeks. I'm grabbing the straws here, buddy. Throw me a bone.
I may have to give you a half a point on that one. Okay, I may have to give you a half a point. So John is absolutely right, though, and what matters is that for in most cases, a temporary layoff is actually illegal. So it's a kind of a trick question. How long can it last? Well, it shouldn't be there at all. Most people, a temporary layoff is illegal. It's a termination. If you've been laid off temporarily, you have the right to treat that as a termination and leave with severance. You don't have to wait. They don't have a right to do it. Now, there are some situations where a company does have a right to lay you off, and in those situations, usually if it's an employment agreement that says that they can, or if there's a past history, in that case, it could either be 13 or 34 weeks, depending on whether the company is continuing benefits. But don't worry about that. For most people, John is absolutely right. I'm going to still give you only half a point.
Whatever.
That a termination is really a temporary layoff. A layoff is a termination. If you've been laid off temporarily, no, you don't have to accept it. You can treat that as a termination, move on, and get your full severance right now.
Let's roll. Next one.
So what are the 4 main factors considered when determining how much severance someone should get?
Okay, 4. We have type of job, length of employment, age, the type of car you drive. There's never been 4. There's always been 3.
Well,
Curveball.
There's always been a 4th one. So John mentioned the 3 big ones that we always talk about: age, position, and length of employment. But there's really one kind of overarching one, which is employability. Okay?
Oh, okay.
How long should it take you to find another job? And that may depend on the industry you're in. It may depend on the state of the economy. Good economy may take you less time, bad economy, more time. So employability. But age, position, length of employment, and employability are the factors that go into determining how much severance you should get. Now, what that means is it's not a week's pay per year of service. It's not 2 weeks' pay. It's much, much more. You can always go to pocketemploymentlawyer.ca to find out how much you're owed. It calculates, assesses those factors: age, position, length of employment, also employability. John, I can't give you that. Sorry.
Yeah. So if you're a fiduciary high up, it's going to take you. The employability is going to be much lower because there's fewer people.
Fewer jobs available.
Burgers.
Exactly. So if you're working in an industry, I don't know, aviation, for example, there's not a lot of jobs. There's not a lot of companies that hire someone to do aviation. Whereas, if you're working in retail, you may find the job easier. So employability, the likelihood of finding another job is always a big factor.
All right, termination pop quiz. Last question.
Last question,
Yes.
John. What is the first thing that should be considered when assessing a person's severance?
Length of employment.
What is the first thing I want to look at? Actually look at?
What's the first thing I want to look at? I'm sweating. I don't know. I know the answer, but I don't know the answer now.
The answer is an employment agreement.
Oh, of course.
And the reason for that, John,
Fail.
is because what some companies do, and I think you know that, is they stipulate in the employment agreement what they have to pay you if at some point down the road they let you go. So an employment agreement is a very important document. A lot of companies try to limit their future severance obligations through an employment agreement. So you want to be very careful with these employment agreements when you start a job. But also, last point I'll make on this, John, is just because you signed an employment agreement that limits your entitlements, it does not mean that it's actually enforceable.
Okay.
In many cases, it's not enforceable. So either way, you have to call me if you lose your job. Even if there's an employment agreement in play, you still have to get that advice. But the first thing I'll always want to take a look at is your employment agreement.
I actually knew that. I just did that for dramatic effect.
Yeah, it worked really well.
And scene. That's it for the quiz, thank God. The number anytime, by the way, now we're moving on, 1-855-821-5900, EMPLOYMENTLAWYER.ca online. Again, that's where you go to catch the radio show. Phone call number 2 from our radio show is coming up right now.
I have a concern that I might be terminated from my job as a concierge in a condominium. I've worked there 11 years, and I just am trying to plan a little bit. Can you give me a hint as to what kind of termination compensation I might expect?
And how old are you?
61.
11 years, 61, concierge.
Exactly. So easy for me to say. Anytime someone calls me, I can answer that question in 10 seconds flat. How much severance? But let's see how anyone can find out on their own how much they're owed or how much their friend is owed. So pocketemploymentlawyer.ca. Let's go to pocketemploymentlawyer.ca and we'll choose the severance calculator function in that tool. And let's see how much this person is owed. So we'll plug that information in. In his role, after 11 years of service, at the age of 61, we can see on the screen right now, 12 months of severance is what he's owed. So easy as that. As quickly as I read it, that's how quick it actually takes to get that information on pocketemploymentlawyer.ca. And remember, the age, position, length of employment, he is in his 60s. He has been there for a good amount of time. So at least a year's pay is what he would be owed in his situation. It could even be more than that. So for his planning, moving ahead, he needs to know how much severance he's going to be owed. 12 months for him. You could do the same thing for you if you're lost your job and you're staring at that severance letter, or maybe you're worried, just like this person. What would happen if they let me go? How much would I be owed? Pocketemploymentlawyer.ca to find out exactly what you're owed. Easy, free, anonymous. Take seconds.
All right, coming up here, the validity of a text message termination. What's that all about? We'll get to that and lots more here on the Employment Law Show. Stand by. It's coming right back.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to EMPLOYMENTLAWYER.ca.
Always check with the employment lawyer first at EMPLOYMENTLAWYER.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to EMPLOYMENTLAWYER.ca.
Always check with the employment lawyer first at EMPLOYMENTLAWYER.ca.
And welcome back, Employment Law Show. John Scholes, Lior Samfiru. EmploymentLawyer.ca is where you go to catch the radio show. And from that radio show, of course, we get a ton of phone calls every week. People want to know stuff. They don't know things, so they ask. We're going to get to phone call number 3 for this show, and I know you want to talk about it, Lior.
Worked for a company for 25 years. They let me go. They said it was performance. I was going through some stuff at home, and they gave me 0 severance. They used the term just cause. They had just cause to let me go. I'm 56, and It's a trucking job.
Well, John, we get questions like this all the time. Oh, I was let go for cause. I said earlier on the show, 90% of the time when you're let go, quote unquote, for cause, it's nonsense. It's not cause. He was let go for performance reasons. Unless his performance was that instead of working, he's hanging out at the bar, that's not going to be cause, okay? Even if his performance is not great, it's not cause. Now, how does he find out on his own that it's not cause? PocketEmploymentLawyer.ca. There's a feature on it that allows you to find out if there is cause on PocketEmploymentLawyer.ca. So let's plug that information just so we can show the folks at home how it all works. So you go to PocketEmploymentLawyer.ca. How long did he work? 5 years. Why was he let go? He chooses the reason from a drop-down menu. In this case, for supposedly poor performance. He answers a couple of questions about, did he do it? He probably doesn't feel that he did. And the answer that we get in the PocketEmploymentLawyer.ca is, yeah, this is probably not a case where there's cause for termination. So pocketemploymentlawyer.ca correctly determines, no, there isn't cause. And of course, there isn't. And I can tell you that this guy, after 5 years, he probably would be owed more than 6 months' pay. You can also calculate that on pocketemploymentlawyer.ca. That's how easy it works. And remember the lesson. You may have done something wrong. It's still not going to be cause unless it's awful. Don't let anyone tell you otherwise. If you're let go, you're owed severance. Check out pocketemploymentlawyer.ca.
And reach out by phone, of course, anytime, 1-855-821-5900. There is also, we haven't mentioned it yet, and we'll get into this, terminationquestions.com. That's another resource for you to ask your questions and get them answered. I'm going to lay one on you right here, Lior, from, again, terminationquestions.com. Says, I was just fired from my job via text message right after I told my boss about my battle with depression and a temporary health condition. Can you help me?
So, I've gotten this a number of times, the termination via text. In and of itself, there's nothing illegal about terminating someone over text. That alone is not illegal. It's not professional. It's probably not
cold.
It's cold. It's not good business practices. It's not good HR practices. I wouldn't do it. But it's not illegal. You got a text message, fine. The real question is the termination itself legal or illegal? Well, this person was let go because of a medical condition, or at least right after he was diagnosed with a medical condition, and depression is a serious medical condition. Well, can that happen? Well, he cannot be let go because of a medical condition. He cannot be let go because he may take time off. If he does, it's a human rights violation. So the problem here is not so much the text message. That's unprofessional, as you say. The problem is he's let go after he tells his employer, hey, I have a medical condition. Now, the employer may say, that's not why we let him go, it's just the timing coincided. I don't buy that. If it looks that way and the timing is such that it indicates that's why you're letting someone go, it probably is the reason. So not only would this person, of course, be owed severance, that we know that already, they may be owed human rights damages. You cannot be let go because of a medical condition, because you have one, because your employer suspects you to have one, because you've taken a medical leave or are going to take one. If your employer ever lets you go in those circumstances, in writing, by voicemail, via text, it's illegal.
We're going to slide another one in here quickly. Again, terminationquestions.com is the resource for these. After spending 2 years at a company as a temporary worker, I was fired. I wasn't given any probable cause or reason. What are the laws surrounding terminations and temp workers?
Very good question. We've gotten that a number of times on our radio show. I certainly get that often in the office. So let's be very clear. The law only recognizes one thing: employment. If you're an employee and you lost your job, you are owed severance. I don't know that I can say that any clearer than this. So that applies to temporary employees. If you're a temporary employee, but you have a job and then that job stops existing, you're let go, the company doesn't need you, whatever it is, yes, you are owed severance. Now, after 2 years, I don't care what you're called, temporary, seasonal, whatever it is. If you're now let go, you're going to be owed severance. Now, if you signed an agreement that says you're there only for the summer, and you knew from the beginning that you're just working for the summer, then at the end of the summer, you're not going to be owed severance because that was the deal. But if you're signed on as a temporary employee without a fixed end date, you're owed severance. So remember, temporary employees do get severance. This may come as a surprise. You may not realize that as a temp, you're still owed severance. As long as you're not there for a specific defined period of time, if you are let go, you're going to get severance as well. pocketemploymentlawyer.ca can help you with that too. Lots of resources as we wrap for another show, terminationquestions.com. That's where those last two questions came from. Employmentlawyer.ca online to find our radio shows and other resources. Help at employmentlawyer.ca to reach out through email. And then finally, of course, the good old-fashioned phone number, 1-855-821-5900. Again, 1-855-821-5900. We'll catch you again on the Employment Law Show. Appreciate you sticking around.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.